So there was one other little thing I wanted to say to you about Article 34. Um, there was, of course, a disagreement. Now, Judge MacMenamin's dissent, of course, is very significant. I say it's one of the more significant dissents that's been handed down by an Irish Supreme Court judge that I can think of. Yeah, over the last number of years, maybe decade, it's certainly very significant. And Judge MacMenamin is, I think he's probably more deeply concerned about the Article 37 development. As we'll see, there's a significant development, very significant development in the majority judgment in Zalewski in respect of Article 37. But there's also that significant development in respect of Article 34, as we've seen. Now, remember, there's no disagreement between them insofar as they both say, in fact, all seven, as I've said, all seven of them say, yes, this is the administration of justice. So MacMenamin was satisfied that the Section 43 element did satisfy the enforcement limb of the MacDonald and Bordegon test. But now, as we've seen, O'Donnell, the now Chief Justice, has effectively set MacDonald and Bordegon test to one side. Now, he hasn't banished it from the stage, but he has kind of qualified it and said, look, it's useful, but it's not a gospel. And Judge MacMenamin does not like that. Okay, one of the reasons he dissents, or one of the points on which he dissents, is on that he wants to disagree with this evolution in the approach that's to be taken to Article 34. And essentially, I think what he says on it is, look, this now means that linchpin provision of the Irish Constitution, which MacMenamin points out is totally foundational to the Irish constitutional order, that justice shall be administered in courts, is now looser, and it's now less sure and less certain. And basically, an autocrat would like that. And he's essentially saying, if an autocrat comes along in this country, perhaps there's one who's talking about running for president at the moment. I don't think he's going to get very far, but you know the idea that he'd be delighted. Now, of course, that particular would-be autocrat, I'm sure, wouldn't quite understand what this is all about, but his people would be delighted with what has happened to Article 34, says MacMenamin, says Judge MacMenamin. And there's a part of the judgment that I want to draw your attention to. I'm afraid I can't point it out what paragraph it is, but where Judge MacMenamin is kind of saying, look, we have to respect precedent. We have to respect that this old test, the MacDonald test, has been there for decades, 5, 6, 7 decades. It actually had developed from earlier jurisprudence, and there's an accretion of wisdom there, says MacMenamin. And essentially what he says is his colleagues in the majority are messing around with that. And they're in particular, they're qualifying the history limb, for example. And MacMenamin says that's deeply uncomfortable, or it's potentially destabilizing, and it's unwise, right? So that's Judge MacMenamin on the Article 34 point. I have to say, I think, and I say this in my article that I've put up as part of the recommended reading, I think that MacMenamin's dissent on the Article 34 point is probably less persuasive than what he has to say on the Article 37 point, right? Because as O'Donnell stresses in his majority judgment, he says, I think this history limb, he says, of the MacDonald test, he's not banishing it entirely from the stage. He says it's best understood in a broader sense and as emphasizing the importance of the existing jurisdiction of the courts, and that any provision subtracting from that jurisdiction or creating a parallel jurisdiction which might render the court's traditional jurisdiction defunct is one which should be closely scrutinized by the courts for compatibility with the Constitution. Now, what I would suggest to you, what he's getting at there is this, that the history limb is not dead in the water now. It's just a defensive shield now. And by that, I mean, It's there protecting whatever was within the jurisdiction of the courts in 1965 when MacDonald and Bordegon was decided. Whatever the courts did at that time, like, basically stays under the judicial power. Now, he doesn't say it definitely stays, but you can read the quote yourselves again. He says, should be closely scrutinized. Anything taking away, any removal of anything that was there in 1965 has to be closely scrutinized for constitutionality. In other words, it's highly likely to be unconstitutional. So the history limb is still a defensive shield. But what O'Donnell is kind of saying is, it can't be understood to mean, and should not be understood to mean, that something that emerges in 2065 or 3065 in the future, in other words, that we would never have envisaged. It cannot mean that that inevitably doesn't qualify as the administration of justice just because it wasn't part of the jurisdiction in 1965. So to me, that makes, I have to say, to me, that makes sense. To me, what O'Donnell has done there makes sense. And I think you have a better approach to Article 34 now following Zalewski judgment than previously. Now, remember, guys, you might say, some of you might think to yourselves or say, geez, can they not come up with a definition of the administration of justice that clarifies this thing once and for all? Well, guys, I say to that is like, you try it, because I guess hundreds upon hundreds upon hundreds of constitutional scholars, judges around the common law world over the last at least century and more have attempted to come up with various definitions, and nobody can. So you kind of, and in a sense, that's kind of what O'Donnell has figured out. And he kind of says you kind of have no choice but to go with the walk, talk, quack approach, impressionistic approach, because nobody can come up with an empirical approach that does the work satisfactorily. Anyway, that's enough about Article 34. Why don't I actually just stop recording there, so that that's another little chunk on the 34 point, and now I'll move on to the Article 37 stuff.